if you have a letter of intent to purchase the property, which is not a binding contract. If you have a preliminary contract, that's another step. You may have a preliminary contract with some deposits. You may have a full-blown contract, but none of those things really, in a practical sense, will obligate that person to actually go through the closing and to complete their obligations for whatever contractual rights there are that have been negotiated. And mainly for the purchaser, that's the payment of funds. But there are other factors certainly and other obligations that the purchaser has to do. And they may get sued if they breach the contract. But until closing, which is a little different than real estate closings, and a lot of times those are interrelated, especially if the business involves real estate. But there is a closing, and it may not be all in one day, and it may not be clean where you can cut it off right on that particular timeline. Most of the time, I would advise clients in most circumstances to not take it off the market unless there's a closing, and certainly disclose to new potential buyers, even though this may kind of chase them away or scare them away, is to disclose, hey, I've got this buyer. It looks like things are going well, but you never know until you close. So I'll keep you in mind. You may or may not want to take a backup contract and backup deposits, although that creates some issues in and of itself, because anytime you start contracting with somebody, there's always the chance of legal exposure and liability. So having said that, you don't necessarily take the business off the market, but you ethically and legally, you need to disclose to other people that may be interested within the marketplace that in fact it's under contract, or that you're doing due diligence, and that you will talk to the person, but you have another one that's in line first. So it's pretty rare where I would just say take it off of the market prior to any kind of closing being done.